y quiero agradecer a todas las facultades por invitarme a hablar con ustedes. Voy a continuar en inglés para ser un poco más preciso, pero si tiene algún comentario o pregunta, por favor parar en cualquier momento y compartirlas en español si le gusta. My topic today is the standard of review in appellate litigation, which is a fundamentally important question as Chile embarks on a civil justice reform project. It's critically important to get right, and so what I'm hoping to do is share the Canadian perspective, not because it is right, but because it's a perspective to consider as you embark on this exercise. The standard of review in appellate questions calls on an appellate court to balance, on the one hand, the truth-seeking function and the importance of applying law consistently from one case to another, against the importance of finality, which carries with it its own questions of access to justice, as well as the trial judge's unique and privileged position, having reviewed the facts of the matter. Any fans of Charles Dickens, the great English author, will remember his classic Bleak House, in which litigation arising from a single will, in the case of Jarndyce and Jarndyce, consumed the entire estate in appeal after appeal after appeal. This novel was intended as a satire of the legal profession, not an instruction manual for civil litigation, and it speaks to the importance of the appropriate standard of review and the appropriate role for an appellate court. Believe it or not, though, there is some danger in discussing standard of review that it may veer into a boring talk, a dry talk, one that loses the audience. And so what I propose to do instead today is to use the facts of a case, a difficult case of Canadian law in which our Supreme Court grappled with the question of standard of review, divided, in fact, 5-4 on the appropriate standard of review, and use the facts of this case to illustrate the Canadian approach to appellate review. The case is Housen and Nicolaisen. The central point, as you can see in this quote from the case, is the role of the appellate judge. The bolded text, there is no suggestion that appellate court judges are somehow smarter and thus capable of reaching a better result, is a very difficult concept to explain to some Canadian appellate judges, but it is the crux of the matter. It is about deference and the situations in which deference is owed to the judge at first instance. The facts, very briefly, a tragic case. Two friends, Housen and Nicolaisen, embark on a long series of parties, drinking as they go, for a period of some 16 hours. The fact that no one comments on the fact that they've been drinking for 16 hours perhaps suggests that in the rural part of Canada from which they hail, this is ordinary course. They have enjoyed themselves thoroughly. They spend a few hours sobering up, and then Nicolaisen decides to drive the two of them home. Housen sits in the passenger seat of Nicolaisen's truck. They pull out of the driveway onto a rural road in the municipality of Shelbrooke in the province of Saskatchewan. They come around a gentle curve, approximately 300 meters in length. They gather speed as they come around the gentle bend, whereupon it turns into a hard curve. Before they get to the hard curve, the truck, likely due to the fact that Nicolaisen is still drunk, begins to fishtail and swerve. Once it hits the hard turn, however, Nicolaisen loses control of the truck. It hits the guardrail. It flips. It lands on Hausen's side, and he is left paralyzed. Tragic set of facts. The parties agree to settle damages. Hausen's damages are set at $2.5 million. The question is how to apportion those damages as between the actors. Hausen, for his own contributory negligence, he got into a car with a friend he knew was drunk. Nicolaisen, not only drunk himself, drove too quickly around the bend, and most importantly and most interestingly, the municipality of Shellbrook. Shellbrook failed to post a sign warning of the hard curve and failed to clear brush from around the curve, preventing visibility for the driver. At trial, the trial judge found Hausen 15% liable, contributory negligence, his own fault. Could not recover that amount. He was going to recover 85% of that $2.5 million that had been set aside for damages. The question was, how do you split that between the municipality and Nicolaisen? The answer the trial judge came to was 50% for Nicolaisen, 35% for the municipality. The municipality immediately appealed, whereupon the Court of Appeal for Saskatchewan reversed the trial decision, finding that Nicolaisen was liable for the 85% of damages not attributable to Hausen. Hausen sought leave to appeal to the Supreme Court of Canada, which brings us to the legal test. And we'll take a break here for a moment from the story to consider what was before the Supreme Court of Canada on appeal. The Supreme Court of Canada has asked the question, did the Court of Appeal for Saskatchewan interfere inappropriately with the trial judge's reasoning in distributing damages, allocating damages as she had? This is a question of the standard of review. How much do you interfere with the trial judge's reasons, and how much do you defer to the trial judge as better placed to decide the issues? Questions of law, very easy. Questions of law, an appellate court in Canada is entitled to substitute its own decision. It doesn't matter how the trial judge came to the reasons. It doesn't matter what the conclusion. What matters is that it's correct. That is the only question for an appellate court. Two reasons for that. First, it is the task of the appellate court to ensure that laws are applied uniformly throughout its territory. And that means it cannot show deference to a lower court judge who is purporting to apply the law. It must be uniform. And secondly, appellate courts are in the business of applying law, and so they have the expertise to do so, expertise that is perhaps not placed at the trial level. Questions of fact, equally easy. The trial judge has sat there, has heard, in our case, literally heard from the witnesses, has been on the front line of this trial, and is presumed to be correct, and more to the point, access to justice requires that the trial judge be presumed to be correct. If, as in Jarndyce and Jarndyce, the Dickens novel, you're simply permitted to argue the case over and over and over again in successively higher levels of court, it does a disservice to the principle of access to justice insofar as litigants are forced to incur unnecessary expense. At a certain point, we recognize that more judging is simply more and not better. And in fact, as one becomes removed from the actual evidence heard in the trial, what we have decided is that an appellate court is less well placed to determine questions of fact. Things get a little bit more interesting when you get to inferences of fact. We're no longer talking about things that were established as fact or things that were said in court. We're now asking the trial judge to draw conclusions based on facts. I know A, I know B, I therefore conclude C. Inferences of fact, again, the Supreme Court of Canada says, are to be judged on a palpable and overriding error standard. The only time you interfere with either a finding of fact or an inference of fact is if it is clearly wrong. That doesn't mean you disagree, and this is what you have to explain to appellate judges when you get in front of them. It's not that they have to like the conclusion. It's that they have to be able to see how the trial judge arrived at that conclusion from the evidence before her. So it is a standard of deference that is required in this instance. This is where the rubber really hits the road. This is what Hausen and Nicolaisen turns on. It's a question of mixed law and fact. It is the toughest area for an appellate court to show deference to a trial judge. A mixed question of law and fact may actually be a question of law. If the trial judge is asked to apply a particular legal test and he gets the wrong test, that is a question of law. And again, on a standard of correctness, it may be reversed on appeal. What's difficult, though, is when the judge gets the right test but doesn't apply it properly. That, again, is a question of law, an error of law. What's most difficult, though, for appellate courts is when the trial judge gets the right test, applies the right test, and comes to a conclusion with which the appellate court disagrees. That is the most fundamental aspect of deference, and it is the core of this decision that split, as I said, the Supreme Court of Canada 5-4. What do you do in those circumstances? And the answer is it depends. It depends on whether this is a true question of law that is going to have precedential effect applied more broadly, or if this is, in fact, a question that is confined to the facts of a particular case. And for questions of negligence, the Supreme Court of Canada says you defer to the trial judge. As long as it's the right test, as long as it's applied, it doesn't matter what the conclusion is unless it is clearly wrong. So a high level of deference. Returning then to our story with Hausen and Nicolaisen. The question here is, did the judge apply the appropriate test? And what you can see here is this is the majority's reasons. And the majority is trying to recreate the trial judge's reasons on appeal. And you can see the majority trying to articulate the test. There's some debate about whether the trial judge got it, but the inquiry is just, did she get the test? And the answer is yes. She realizes that there is a dangerous curve in the road. She looks at the standard of the average motorist, and she concludes that it would have been reasonable to put up a sign. So she's got the test for negligence, she considers the variables, and ultimately she comes to a conclusion. Now you can attack that conclusion. You can say it's wrong. You can say that because Nicolaisen was already fishtailing with his truck before he gets into the sharp part of the turn, putting up a sign there would have done nothing. You can say that the result is wrong. But that's not the language in which you have to challenge on an appeal. The fact that the conclusion is not what you would have reached is not sufficient to reverse the conclusion of a trial judge. It must rise to that level of being so clearly wrong that it could not have flowed logically from the facts. And so the end of the story here really is the trial judge's reasoning. And that is the deference that the majority of the Supreme Court of Canada shows to the trial judge. By contrast, the minority of the court, the 4 judges, are forced to grapple with an idea that she got the wrong test. They're trying to shoebox or shoehorn, pigeonhole her reasoning into what they say is clearly a misapprehension of the legal test. That's the kind of approach they have to take, because they can't say what they really want to say, which is they would have done it differently. The I would have done it differently standard is not one known to appellate review in Canada, and it is ultimately one that has no place in our system, where we privilege the trial judge's review of what we consider to be the action as it happens in the trial before her. The other piece of this is the inference, and we talked about this earlier, again, assessed on a standard of palpable and overriding error. The inference that is drawn by the trial judge is that because there had been accidents on this part of the road before, because the municipality was aware of those accidents, those are facts that are established, therefore it was aware that it had a dangerous road. And as a matter of statute, its liability can only flow from the fact that it was aware it had a dangerous road. This is an inference. It is an inference with which the minority of the Supreme Court of Canada disagrees. But again, they're stuck in deference. You can't say, I would have drawn a different inference. The only way to attack a finding on an inference of fact is to say that there was palpable and overriding error in the process of drawing the inference. Very high standard. Again, it privileges the trial judge. And again, it is ultimately unassailable on appeal. The other aspect that I wanted to cover in my talk, because it's become an increasingly important part of Canadian practice, is how you transpose these standards from the court to the administrative sphere, where we delegate to increasingly specialized tribunals the function of assessing and deciding particular matters that come within their jurisdiction. This is a really boring case in which the Supreme Court of Canada was asked to decide about a procedural measure so mundane as whether to extend time in which to render reasons. It's a tribunal's decision. It's a specialized tribunal. The facts of this case don't matter so much as the clear result. The clear result here is that our courts will presume for administrative tribunals acting within their own sphere of expertise, including the interpretation of their constituent statute, that reasonableness, deference, is the standard to apply, even on questions of law. So in effect, more deferential than the treatment of an inferior court. And this is important because it recognizes the development of a consistent jurisprudence at the level of the administrative tribunal. Much as we privilege appellate courts in allowing them to make law that will be applicable in a general sense within the territory and applied uniformly, we look to the tribunal itself to generate that same uniformity, and we consider the appellate court to be the interloper that does not have the same sort of specialized expertise. So we really defer to administrative tribunals, and the only time that we come into correctness are on very narrow questions of law that we don't see coming within the administrative expertise of a particular tribunal. We're talking about constitutional questions. There's no reason that an administrative tribunal, here the Information and Privacy Commissioner, there's no reason that it should be interpreting constitutional measures in any way that would preclude an assessment on a standard of correctness by a court. But for most everything else, we're really looking for that kind of reasonableness that allows for multiple interpretations. And the leading case in Canada is Dunsmuir. I should mention that all of these cases are available for free on the Canadian Legal Information Institute's website, CanLE, if for any reason you have interest in reading the full version. The discussion of reasonableness in Dunsmuir is instructive. It essentially says There are lots of possible ways that you can come to a conclusion. There are lots of possible conclusions you can derive. What we're really looking for is something where one follows the other in a logical sequence and arises from the evidence that was presented before the tribunal. This is a pretty high level of deference. It's a pretty conservative approach on the part of our appellate courts. It is one that can be frustrating to litigants that lose at first instance. But as I've said, it is one that recognizes the particular expertise of a tribunal and folds that into the recognition as well that tribunal justice is intended to deliver greater access to justice by reducing the costs of bringing a matter before an individual who is able to provide resolution, not a judge necessarily, but a tribunal member. And so within the context and the purpose of administrative tribunals, this additional approach to deference makes sense. And so increasingly, I would say, the trend in Canadian law is one towards deference to courts and tribunals of first instance. It's one that is of recent invention. It is one that has until recently been controversial. It is one that does not come from any statute. It is entirely judge-made law. But it is one that has been applied in recent years with a fair degree of regularity and uniformity. And it seems to be working for us. It's not to say it would work for anyone else, but it does seem to be, on the one hand, ensuring that we do have truth searching where it is needed, on the other hand, finality where it is appropriate. And ultimately, I hope by sharing it, that it provides some context and some background for the exercise in which I understand Chile is engaged. I would be happy to take any questions. I hope I haven't bored you all to death, but if you have any questions with the standard of review, I would be happy to tackle them. Otherwise, I certainly thank you very kindly for your attention.